Hello guys, thanks for tuning in. I welcome all of you to my YouTube channel Legally Determined. I am a practicing advocate in New Delhi and have been running a law firm in the name and style of Sahinta and Wycombe. Sahinta and Wycombe is a full-fledged law firm. I am a dyed-in-the-wool advocate who knows how to make a blitzkrieg in the court of law and knows how to knock his opponent into a cocked hat. I have crafted a high quality vid to hook my viewers and keep them viewing. I inter alia advise on corporate law. In this bull session, I will demystify the shell companies. I want my viewers to stick around for the entire episode across this vid. My opinion matters because I am an advocate and have chops in this arena. This vid's target audience are corporates, lawyers, advocates, judiciary, chartered accountants, company secretaries, or anyone fascinated by this hobby yours. My viewers will benefit galore from this episode. Please like, share, and subscribe to my vid. Why do people form shell companies? This bull session intends to analyze shell companies, the objectives with which these companies can be set up, and the regulatory response to their existence and misuse. Question 1. What are shell companies? The term shell company has not been defined anywhere, but shell companies mean companies which are set up only because it leads to the creation of a separate legal person and does not actually have any business operations. Sometimes these may have been set up with an objective of doing business in future, but more often than not, the promoters never intended to carry on business through these companies. For reference, we can draw upon the definition of a shell company as contained in the US Code of Federal Regulations CFR Title 17 Chapter 2 Part 230 Section 405. This section specifies a shell company as having the following characteristics: no or nominal operations, and either no or nominal assets or assets consisting solely of cash and cash equivalents, or assets consisting of any amount of cash and cash equivalents and nominal other assets. Shell companies are therefore like mailboxes and are often referred to as such, which are used to deposit and remove letters without retaining anything inside it. There are no operations and no nominal assets, but the legal personality can be used as a pass-through for some transactions or assets. Question 2. Why should you know about shell companies? If you invest in a shell company, your money could be used for illegal purposes and may even not be recoverable given the government crackdown on these entities. Investment of approximately 36 lakh investors got stuck when the SEBI placed trading restrictions on 331 stocks suspected to belong to shell companies. Question 3. Why do people form shell companies? The following are some of the purposes for which shell companies can be formed: as layers to hide identities of real owners. In this case of shell companies, it will be difficult to locate the precise ownership, the registered office of the company, or the directors, and whatever nominal assets the company may have will also be at an entirely different place than the location of the registered office, as may have been filed with the registrar. In short, it will be difficult to locate any people or business operations. For tax evasion, shell companies can be used to create a separate tax entity, and the income of a person or entity will be transferred or shifted to the shell company so that the tax on the original recipient of such income can be reduced or avoided entirely. For money laundering and siphoning of black money, this is the reason why shell companies suddenly started being discovered during the demonetization drive of November 2016. A significant number of shell companies were used to deposit surplus cash so that there would not be excessive deposits of cash by the original holders. There were instances of shell companies being created on the basis of fake or stolen identity documents of people who had no idea about how their identity documents were being used. For Ponzi schemes, The Ponzi scheme is named after Charles Ponzi, an Italian-born American swindler who tricked investors in the 1920s with a fake postage stamp investment. A Ponzi scheme is a type of investment fraud where promoters use money from new investors to pay returns to earlier investors. Promoters lure investors with promises of high returns and low risk. They use the moolah from new investors to pay off earlier investors and keep some for themselves. Ponzi schemes collapse when it becomes difficult to find new investors or when existing investors cash out. Fraudsters can use shell companies for defrauding people by creating Ponzi schemes so that eventually, when the fraud is discovered, the box or the company is all that remains and the real people behind the entity would have escaped, probably out of the country. For shifting incomes to tax-neutral jurisdictions. This happens in international transactions and may be on the borderline of being within or outside the law, depending upon how efficiently the tax treaty provisions are used. Question 4. Given the objectives above, shall companies violate the following laws? The Companies Restriction on Number of Layers Rules 2017. Under these rules, companies other than banks, NBFCs, insurance companies or government companies are not permitted to have more than 2 layers of subsidiaries, barring one layer of one or more a wholly owned subsidiary or subsidiaries as per Rule 2, Subrule 2 of the rules. In this regard, it is to be noted that Section 186, Clause 1 and the explanation to this section clearly provide that this restriction shall only be applicable on investment companies, namely companies that only hold shares or other securities and do not perform any operating functions. Since tracing the source of money in such cases becomes difficult when layers are formed for the sake of acting as pipelines, imposing the restriction was important. However, if the layers are operating layers, namely they actually perform activities other than simply holding the securities, this restriction will not be applicable. The Benami Transactions Prohibition Amendment Act 2016. This act gives the government power to confiscate Benami assets, namely assets which have been held in the name of another person or fictitious person, to avoid taxation and conceal unaccounted for wealth. The Prevention of Money Laundering Act PMLA. When the money on which tax has not been paid, namely unaccounted or black money, is passed through a shell company to reflect it as untainted money, it results in the offence of money laundering under Section 3 of the Prevention of Money Laundering Act and is punishable with rigorous imprisonment for a term between 3 and 7 years and a fine. The Bhartiya Nyaya Sahinta Section 318, where shell companies are used for Ponzi schemes, it results in the commission of an offence under Section 318 of the Bhartiya Nyaya Sahinta BNS relating to cheating, which is punishable with imprisonment for a term extending to 7 years and a fine. The POEM, the Place of Effective Management, guidelines issued by CBDT, Central Board of Direct Taxes. Shell companies can be set up in tax havens out of India and the income can be artificially shifted to such jurisdictions which are liberal in taxation. The Place of Effective Management POEM guidelines provide for the determination of a place of effective management of an entity, and where this is in India, the Indian tax laws will be applicable. Black money, undisclosed foreign income and assets and Imposition of Tax Act 2015. Next question, what is the difference between dormant and shell companies? A dormant company gets its title in 3 ways. If it has opted for getting a dormant status from the ROC Registrar of Companies by way of an application. Second, if it is in compliance of the requirements of Section 455 of the Companies Act 2013. Third, in case a company has not filed financial status or annual returns for 2 financial years consecutively, the ROC shall issue notice and include it in the register of dormant companies. Next question, what actions can be taken against shell companies? The ROC issues a show cause notice to such companies and their directors seeking their response within 30 days. If the response is not satisfactory, the company's name would be removed from the register. Then companies have to make an application before the National Company Law Tribunal (NCLT) for the restoration, which the NCLT will decide on a case-to-case basis. Next question. Are shell companies always created for illegal purposes? No. It is not necessary that a shell company is engaging in illegal activities. Though till now we have only discussed how shell companies can be used illegally at times, shell companies work within the legal limits as well. Let us look at an illustration to understand how shell companies can work legally. Company X creates a subsidiary solely for looking after its HR functions. Now, this subsidiary does not engage in any form of trade or business because it neither has any significant assets nor does it have real business operations. This subsidiary can be considered as a shell company, but it is not illegal. Assam Company India Limited versus Union of India Writ Petition Civil number 257 of 2018, a company owning a substantial number of tea estates, producing millions of kilograms of tea on an annual basis and feeding thousands of families, was termed a shell company. The court held that considering the negative implications of being branded as a shell company, it was not justified to treat the company as a shell company. The legal reasons for which a shell company can be created are: hold or store money temporarily when the main company or owner of the shell company is planning to start a new company. If a company wants to hide its dealings with another company which has a bad reputation, it may create a shell company solely to engage with the other company. Next, a shell company may be created to stage a hostile takeover. This happens when a company buys another company without the approval of the management of the target company. Next, to protect assets from lawsuits in case a company is working in a dangerous country, for instance with rampant terrorist activities, then people may formulate shell companies to hide money in order to avoid being a target of criminals and thieves. Shell companies can also be created to gain access to foreign markets. As mentioned, creation of shell companies is not an offense. However, some issues arise with establishing a shell company. These are as follows. In case a company forms a shell company offshore, it can lead to bad publicity as profits are being sent out of the nation, while not necessarily illegal. Using a shell company to hold assets in it falls in a legally grey area and could lead to legal issues. Hence, it is definitely advised not to create shell companies. Next question. Concerted action on shell companies by the regulators. The action began with the regulators launching a two-pronged attack on the shell companies. A task force on shell companies was set up under the joint chairmanship of the Revenue Secretary and Secretary, Ministry of Corporate Affairs in February 2017. Investigation by the Income Tax Department led to the identification of shell companies which were used as conduits, and criminal prosecutions were launched by the Income Tax Department against the beneficiaries of non-genuine transactions. The Ministry of Corporate Affairs targeted the shell companies with deregistration. The first point of the attack were companies which had not filed their financial statements. Section 248 of the Companies Act 2013 authorizes the Register of Companies to strike off a company from the Register of Companies where the company has failed to commence business within a period of 1 year from the date of its incorporation, or upon notice to the company and the directors of the company has failed to carry on business for 2 financial years and has not applied to obtain the status of a dormant company. Over 2 lakh companies were struck off under this section, and the MCA placed a list of these companies ROC-wise on their website. Further, the MCA also put up a list of directors associated with these companies. The directors of these companies were disqualified to act as directors of any other entities for a period of 5 years. The banking operations of these companies were also restricted and the directors were disallowed from operating their banking accounts. The Securities and Exchange Board of India (SEBI) directed the stock exchanges to suspend the trading of 331 suspected shell companies in August 2017 and ordered a forensic audit of 11 of these companies. The Serious Fraud Investigation Office (SFIO) identified 49 shell companies in February 2017 where money over rupees 3,900 crore have been laundered and where company position have been filed for these companies and the process for their winding up initiated. As of October 2017, the SFIO was also investigating 1,505 companies for violating the Companies Act 2013 and another 809 companies found untraceable by the SEBI. The Enforcement Directorate conducted a nationwide search in April 2017 in respect of shell companies and related professionals who were behind the creation and operation of these companies. As of October 2017, after unearthing USD 1 billion in suspicious transactions, the government was also considering limiting the transfer of property for these entities. Given that the government is keen on its objective of increasing the ease of doing business, and this is directly proportional to the reduction of corruption and parallel economy, it can be said that the existence and operation of shell companies will continue to get increasingly difficult. However, on account of there being huge opposition to the disqualification of the directors, the MCA has come up with the Condonation of Delay Scheme 2018 Voided General Circular dated 29 December 2017, offering relief to such disqualified directors. One of the reasons why this might have been implemented is that disqualifying the directors took away the chance from the company to rectify the defect and complete the annual filings. The condonation scheme permits the defaulting companies to condone the delay up to the 30th of April 2018. Accordingly, up to 30th April 2018, such companies can file their annual returns, compliance certificates, and auditor's appointment form for the entire period of default. For this purpose, the DIN of concerned directors will be revived temporarily and all those forms can be filed with the additional fees up to a maximum of 12x times the normal fees. Further, after the aforementioned filing, companies must file a form to condone the delay, paying a fee of 30,000 rupees. Once all these forms are filed and approved, the DIN will be revived permanently and thus the disqualification will be cured. I have made this vid off the hook. Thanks for watching this vid. Break a leg.